Ready? 3, 2, 1, start. From the pleadings before the court, it transpires that the respondent number 1 has initiated proceedings against the petitioners under Section 15 of the Payment of Wages Act 1936, hereinafter called the Act for Recovery of his wages from them who are indisputably the employers and persons responsible for the payment of his wages. Stop. The proceedings are pending before the city magistrate, the respondent number 2, who is the prescribed authority under the Act. Stop para. In the said proceedings, the respondent number 1 moved an application under Section 17A of the Act, praying that the movable and immovable properties of the petitioners specified therein be conditionally attached. Stop. The petitioners filed their objection. Stop. Therefore, the respondent number 2 passed one-line order dated November 16, 1977, directing the petitioners to furnish two sureties, otherwise their properties mentioned at item number 1 within bracket A to 2 within bracket B be attached. Stop. A copy of the order has been filed along with the petition as Annexure 5. Stop. The order was followed by a communication from the respondent number 2 to the concerned police station requiring implementation and enforcement of the order dated November 16, 1995. Stop. A true copy of the said communication is Annexure 8 to the petition. Stop. The order and the communication aforesaid are under challenge in this petition under Article 226 of the Constitution of India. Stop para. Learned Standing Counsel appearing for the respondents number 2 and 3 submits that the impugned order dated November 16, 1995 is perfectly legal, having been passed by the prescribed authority within the four corners of its jurisdiction under Section 17A of the Act, which did not oblige it to give reasons. Stop. He therefore submits that the order is not liable to be interfered with and ought to be upheld. Stop. Tested on the above touchstone, the order dated November 16, 1980 fails. The order is one-line order disclosing no reasons, rendering it absolutely impossible to know as to what contributed to the satisfaction of the respondent number 2 that the petitioners were likely to evade payment of the amount that may be directed to be paid to the respondent number 1 under Section 15 of the Act, and also to the formation of his opinion regarding the quantum of property, attachment whereof was necessary to satisfy the amount that may be required to be paid to the said respondent number 1. Stop. The order dated November 16, 1980 is therefore clearly invalid and cannot be upheld. Stop para. Though I agree with the view of the matter taken by my brother Vivek Singh Thakur, judge, in allowing this appeal and acquittal of the accused from the charge framed against him under Section 20 of the NDPS Act 1985. However, not on all the reasons recorded in the judgment. Stop para. Ram was deputed in search of independent witnesses, returned to the spot after 15-20 minutes. Stop. Therefore, the variance of 15-20 minutes may be on account of memory faded away with the passage of time is not fatal to the prosecution case. Stop. If coming to the NCB from Exhibit PW3 as per the same, 7:15 am is the time of seizure of the contraband allegedly charas recovered from the accused and not that of its recovery. Stop. The seizure takes place after the recovery of the contraband and the seizure memo is prepared after sealing process is over. Stop. Over.